Hi, my name is Scott Nelson. I'm an attorney from Glastonbury, Connecticut. And today I'm reaching out because you clicked on an ad that we had running on Facebook and you filled out a survey saying that you were interested in avoiding some of the costs and delay that your family would face going through probate. So typically what we do is I set up a Zoom meeting and I share a little presentation that I made showing you what your options are in the market today. It's 100% educational, and throughout that process you can ask me questions relative to how that might affect your family or even some of the family issues you might be faced with, and so we could discuss those. But since we don't have that luxury, I'm going to go through that presentation today. And then if you have any questions, you have the opportunity to either call me or text me or email me and say, I'd like to set up a meeting to kind of go through some of the particulars. So let's get started. This page here is essentially a graph explaining on the cost basis of what your options are in the market today. On the very low end of the spectrum, it's going to be on the left side, and then your highest cost is going to be on the right side. And so typically we start off with the do-it-yourself plans. And one of the big issues with the do-it-yourself plans is that you have to do it yourself. And so if you have a question, who's going to help you make sure you're making the right decision for you and your family? Now, in all fairness, they typically have a little question box you can click, but invariably it has a 800 number for you to call, and the person on the other end of the line is going to say, well, you need our more expensive program, it sounds like. And so that's one issue. And then the other issue is that it only provides three major documents. And that is, it provides a typical simple will, which does not mean it's a bad will. It's just a will that does not involve a trust. And what that says is the husband dies before the wife, everything goes to the wife. And if the wife dies before the husband, everything goes to him. And then if they die simultaneously or at the second death, everything goes to the kids. So that's what a simple will does. And then they typically provide a durable power of attorney, which is somebody that acts in your behalf if, let's say you're on a cruise somewhere and you need something signed in your hometown. Well, that person who holds that authority can sign as if you were there in person. So it's a very handy document. And then they also typically provide a healthcare power of attorney that says, look, if you've been in a car accident and you're unconscious and your thumb needs to be sewn up, well, the doctor is not going to do that surgery without consent. So the person who has the healthcare power of attorney can tell the doctor, yeah, it's okay to sew up the thumb and give them some pain medication. So that's a handy document to have as well. But what's important in today's discussion is that a simple will does not include or involve a trust. And then one of the things we've discovered is pretty alarming is that the sale of your information is rampant in these programs. Now, I know we're all guilty of this, but when you get online and you want to start a program or get involved with a different kind of website, they have that little user agreement, and you click that little I agree button to get started. Well, guess what? Buried on about page 36 is a little statement that says, you agree to allow us to share your information with our affiliates and partners. And who's that? Well, it turns out that's anybody that will pay for your information. And they make a lot more money selling your information than they do on, the little document that they're preparing for you. And so now you've subjected yourself and your family to people knowing your address, your email address, your phone number, who your beneficiaries are. And now you've just opened up everything for targeted marketing campaigns against your family. So I don't know how you feel about that, but I would just totally avoid those at all costs. Now, on the other end of the spectrum is going to be your full service law firm. So if I only had two choices, I would always go with the full service law firm. They're always going to be there to be able to answer the questions. They have fully licensed attorneys. They have first and second year associates that have just graduated law school. They have paralegals and support staff. But, those have a cost associated with them, and it is going to be a lot more expensive. So they're going to package their pricing, but when they do that, they have a hidden agenda. So I'm going to pull back the curtain a little bit on the economics and business of a law firm and kind of explain what that hidden agenda is. When you sit down with them, they are under no obligation to talk to you about these services because they haven't happened yet. But they really want to be in a position to be the trustee or successor trustee under your trust document. They also want to do the probate administration on behalf of the family. And I bolded that for a very specific reason, and you'll see that in a couple slides going forward. Of course, they want to be your legal consultant because every time you call them up, they're going to charge you by the hour. And every year they want you to come in and have a review with the law firm to see if anything has changed. And again, that's also an hourly cost. When you look at the trust plans itself, and today we are really going to spend more time on the trust plans because for 99% of our clients, a trust is more appropriate than just a will. And they're going to price these anywhere between $4,000 and $8,500. I think you'll see an average of about $6,500. I go to estate planning webinars for attorneys every month. They're all talking about this in certain ranges. And then they say, here's what we're doing to bring even more value to the law firm, not value to the client. So, they're going to try to get as much as they can. And that's really interesting that prices have come down a little bit. My father died in September. He paid $12,000 for his plan. It was pretty complicated. Me, as an attorney, I cannot write a plan if I'm a beneficiary. So I have a twin brother. We're the only beneficiaries of my dad's estate. So while I reviewed his documents, and it hurt me on the inside that he was paying that much, at least we got the job done. My brother had been divorced, and he paid $7,500 for his plan. And I think prices have come down a little bit since that time. So they're also going to charge you for their consultations. They typically will give away the first hour. And so you've come into their office and you sit down and you tell them everything about your family. And psychologically, are you really going to shop around? I mean, you're going to tell that same story to 3 or 4 attorneys in different offices. So they know if they've got you coming in, they have a pretty good shot for writing this trust package for you and your family. Well, today with technology, you have some options that didn't exist before. And the people who have developed these options are taking the savings that would give them more profit and in turn giving it back to the client so they can get the same or exact same products or services that you get a full service law firm, and you won't have to pay as much. So I'm going to go through 2 really good considerations that I've discovered in the marketplace today, and I think they're appropriate in 2 different situations, and I will go through those, but you should be aware that these exist. They're going to give you the same or better documents than the law firm is. And you might say, well, how can you do that? Well, a law firm uses a Word program, and they cut and paste your document according to your interview and your needs. And when you bring in paragraphs from other documents, sometimes the names don't get changed. And even though you're looking at it and you see a different name there than what's supposed to be there, your brain says everything looks fine. Because if you're a paralegal or first year associate that's been given this responsibility, usually just a couple hours before you come into the office, they're under a tremendous amount of time pressure. And sometimes, the brain just takes over. And if you catch the mistakes, the attorneys are pretty much trained to say, oh, good catch, well, that's why it's a draft, and all of those things. But I am excited to say that these software programs don't have that problem. So it takes a lot of the pressure off shoulders as far as reviewing documents before the client comes in, because those mistakes cannot happen in the program. I might misspell a name or two, but we pick that up and correct it pretty fast. But the documents are not going to have different article numbers that were pulled in from different trusts from other clients. And so those are really important to kind of just have a nice, well-written plan. And what's the biggest bonus is these documents are state specific. They're valid in every state, and they're written for every state that our clients reside in. And they're attorney assisted. So you have someone to help you through making what is going to be the best decision for you and your family, because beneficiaries, are all different. So it isn't just a boilerplate statement saying, X, Y, and Z gets this much money. We can tailor this, and I'll get into the options of these programs, but it is very robust. So I think overall your best long-term value would look at and consider these two other programs that we're going to discuss today. Why a revocable trust? Well, a revocable trust is just a piece of paper. I grew up in Kansas. When I heard somebody had a trust, I thought, wow, they really must be rich, or their situation is really complicated. But it is just a financial tool for the people that had money. It was a way for them to save money. The Revocable Living Trust has three major benefits. One is it avoids probate, which is a lengthy and costly process, and having this document will save your family tens of thousands of dollars. It also is private. Nobody knows what assets are going to what beneficiary or when they're receiving it. So you're not sitting there and your next door neighbor knows how much is in your checking account. It is completely private, and nobody needs to know your business. And the document itself is very flexible. You will not see a difference or any restrictions from what you're currently doing. So you can go on with your day-to-day activities as you have been your entire adult life, and you will not see any difference. Just think of a trust as your left pocket versus your right pocket. You can change it whenever you want. That's what the revocable word means. And it allows you to determine today what's the best financial decision for each beneficiary. It's very flexible in that if those circumstances change, you can make those changes. So not making a irrevocable decision going forward when you have a revocable trust. If we look at your estate, it's comprised of 6, maybe 7 major buckets, but we have your cash and savings, your investments, like at a brokerage account, or if you own any stocks or bonds, your real estate, your retirement assets like your 401k and IRAs, any business interests you might have, like a partnership or an LLC, and then your other assets. That'd be like vehicles, jewelry, collections, personal effects like that. So at death, the first question that is always asked is there a trust? Because if there's a trust, then you don't have to worry about going through probate. If there is not a trust, then you're going to go through the probate process. So your assets will all be bundled together. You go through the probate process, and once that process is over, then your will, if you have one, determines who gets your property. So at that point, it goes to family or cousins or best friends or charities or all of the above. If you do not have a will, it's called being intestate. And that's a little bit more complicated. So whether you have a will or you don't have a will, you're still going to go through this probate process, and you have to get on the docket for the probate judge. And then if you don't have a will, they're going to appoint an administrator, which is the same type of responsibilities that an executor would have if you had a will. And they're kind of the quarterback to make sure that, everything is followed the way it's supposed to go through the probate process. You have these statutory fees that's, mandated in each state. They want you to hire attorneys because they have no interest in educating your family members on going through the probate process and what needs to be filed. So they prefer if you did and hired a law firm to do that for you. A bond has to be posted for the estate process, and these are all expenses that come out of the estate. So then you have to take an inventory, and sometimes that requires appraisals. And then there's a publication in your local paper and on the internet, basically allowing creditors to make claims against the estate so that the estate knows that there are these debts that have to be paid. And then once they prove that those debts have been paid and the taxes have been paid, then there's a division of the assets. And here's the real shocker. If you don't have a will, the state is going to determine who gets your property. And there's kind of a hierarchy of distribution. So typically, the first thing they'll look at is at the family. Who's still alive? Is a spouse still alive? Do you have brothers and sisters? Do you have parents? Well, it's possible you may have wanted to make distributions to all those people. So they're going to make accommodations for that. And then they look at children. Are your children adults or are they minors? If they're minors, then the administrator is going to appoint, or so is the probate judge, a guardian for the person to raise that child. And then they're going to take them through a little financial interview and find out, how good are they with finances? And if they're not so good, they're going to appoint a guardian for the property of that minor child to manage that property until they're the age of 18, which is the age of majority, is what they call it. And then, guess what? The kid gets the money at age 18. So I don't know what your money management experience was at age 18, but I probably would have bought a car. And that may not have been the best financial decision I could have made with some inheritance. So in these schedules, they look at, all right, typically what we want to do is give the first $10,000 to $100,000 to the surviving spouse. And that's going to be different for every state. And then they typically split the estate up 50% between the spouse and the children. And that can put the spouse in a really difficult position because a lot of jurisdictions do not like real estate going to children, especially minors. So the home will go to the surviving spouse, but all the liquidity, the investments and retirement accounts, a lot of that will go to the kids. So mom has to borrow money from the kids in order to maintain the house or maybe even pay the taxes, depending on, what's set up in their particular situation. That is a pretty lengthy process. And then what happens with creditors? So I kind of make fun of this, but imagine Billy Bob, who's living in a van down by the river, and he sees that you have died in the paper. And he goes, you know what? I think John owes me some money. So he makes a claim to the probate judge and says, they owe me $8,000. Now the attorney comes to the surviving spouse and says, we've got Billy Bob here. He says that he is owed $8,000, and the spouse may never have heard of Billy Bob. In fact, nobody has ever heard of Billy Bob. So the probate judge has to litigate this claim. So the attorney comes to the spouse and says, all right, we've got this $8,000 case against the estate, but it's going to cost you $12,000 to litigate it. What do you want to do? Well, do you really want to spend $12,000 to prove you're right against an $8,000 claim? And so all of this can be avoided if you can just make sure when there's a publication, no one can see how much money there is in this state because they're not going to bother with it. And if it's a really savvy attorney that's looking out for your best interest, they're going to make an offer to Billy Bob, maybe $1,000, $2,000, and see if they'll go away. If they go away, then you know it's kind of a bogus claim, but you saved $10,000. Other attorneys are going to be different. They're going to want to litigate that because that's an additional source of revenue. You don't even want to be in that position. So even if there's a less than 1% chance of you being in that situation, wouldn't you like to avoid it at all cost? Then there's the cost and delay of probate. So you take all these assets and then the probate fees are calculated on the gross estate without any regard that there might be a mortgage on the real estate or income taxes due on your tax deferred accounts, or even built up equity in a business, and you're not going to be able to sell that business without taking a horrible financial hit. But they're going to take this gross estate, and it's somewhere between 4 and 8% of the estate. And so if you had a $500,000 house, that could be as much as $40,000, and that's just on the house. And that $40,000 is split between the executor or administrators and the attorneys. So when I talk about kind of the unethical part of the business of a law firm, they're under no obligation to tell you that they're going to make 10 times more money taking you through the probate estate than what your documents were generated in order to avoid it. And so that's a huge issue. And then you have the bond appraisals, you have filings. I mean, there's nothing more frustrating to me than to go to the probate court to get some filings. They charge me $3.50 a page, and there might be 2 sentences on some of the pages. Well, that just drives me crazy. So on average, if you just take 10% of your gross estate, that is pretty much what you're going to be looking at as far as the cost of probate. And that's why no one is very happy with that process. And then the delay, it can take anywhere from 18 months to 24 months on average. If there's litigation, it could go to 3 to 5 years. It's only after all those costs have been paid and paid in cash does it finally get down to your family, whatever is less. So I think you can all agree that probate's pretty grim and we don't want to go through the process. So when you look at avoiding that, you're going to want an estate planning package that has some pretty comprehensive tools that allow you to avoid that. The first of which, of course, is a revocable living trust, and it has a lot of options. So I'm only going to go through the tops of the waves here as far as the options, but you have capabilities to be able to make sure that every single beneficiary is taken care of. And what that means is we can individually customize this document to be perfect for you and your family. So that is really important, and that goes to the flexibility of the document itself. Then we provide a certificate of trust. So funny story, when my father died, I went to his law firm. I said, I need a certificate of trust. And the senior partner said, oh, well, you have to sign an engagement letter with a law firm. And I looked at her and I said, well, why would I want to do that? Because she obviously forgot that I was an attorney. She goes, well, you're asking for a new document, and so you have to hire us as, the trustee to be able to provide that document. And I looked at her like she had 4 eyes, because I said, you don't provide a certificate of trust for your clients? She goes, oh no, that's extra. So it took me a second to recover, and I said, okay, well, how much does it cost? Because if I can take that obligation off my checklist and they do it cheaper than I could, well, I'll just have them to do it, no skin off my back. So she goes, well, I charge $660 an hour, but we'll have my associate do it, and she only charges $330 an hour. So that didn't really answer my question. So I said, okay, well, how much does it cost? So she goes, well, it's going to take about 2.5 hours. And that's when the inside of my brain kind of blew up. I said, all right, so I'll take care of that. She goes, you'll take care of this certificate of trust by yourself? I said, yeah, no problem. Because you need 3 things. You need to know the name of your trust. Well, I've been working with my dad's trust since 1993. You need to know the name of the trustee. Well, I have a twin brother, and there's me, and I'm the attorney in the family, so guess who gets to be the trustee? So I know the name of the trustee, it's me. And then all you need is a tax ID number. And if you just go for trust tax ID number with the IRS, it takes you to their website, and in about 6 minutes, they will issue you your tax ID number. So that took me about 12 minutes. I did not pay just under $900 for that certificate of trust with the law firm, and you shouldn't have to either. Both of these programs provide that document. That's just a value added for these programs, and that is for your benefit. They also provide a last will and testament, but this one's different than a simple will. This one is called a pour-over will. It's a really short will because it doesn't do much, but it's really sophisticated, and it helps the attorneys and the family out because it says whatever I own that didn't get retitled in the name of my living trust is going to pour over into the trust, because the trust is going to be your instrument that distributes your property. And when you look at the options that you have up here, that shows everyone, or especially the trustee, of how to distribute the property. It's beautiful in that nothing falls through the cracks. You got to have a pour-over will with a revocable living trust, and that makes sure there's never going to be an issue with assets that are going to go through probate. Then, of course, the financial power of attorney, the healthcare power of attorney, and a living will. And a lot of law firms still feel necessary to charge extra for the living will. And that says, look, if you're brain dead and you're hooked up to a machine to breathe and they're feeding you through tubes, do you really want to be a medical experiment to see how long they can keep you alive? You're never going to come back and enjoy the life that you once led. Is it possible that it's okay for the family to pull the plug, so to speak, and save some money, let you die a dignified death, and then move on? A lot of people think that's a very good financial decision, and you have that choice. Do you want pain medication? Most people say yes. Do you want to contribute any organs? Some people say yes. Some people say, I don't know if they'd want any of my organs. So you have that option. So those are the main documents. There are more depending on your needs, and they provide those as part of the whole package. So you're not restricted to only these, but these are the really good ones to have. So how to avoid probate. We get a trust drafted, and then after you've signed that document, you start renaming and retitling assets in the name of your family trust. And attorneys like to talk about funding the trust. Well, that's what that does. You're renaming the account from, let's say, John and Jay Doe on the checking account to now the Doe Family Trust, John and Jay Doe Grantors, under trust agreement dated 6/15/2025. When you make that change, the bank isn't going to charge you anything for that. And when you make that change, now your statements will come in the mail, and it'll have the Doe Family Trust, language there on that mailing address. And that means you funded the trust with that asset. So you do that with your checking and savings account. You go to the brokerage and you tell them, I want to change the name of my brokerage account to the name of my trust. They all have their forms. They've done it hundreds of times. The only thing that really costs you money It's transferring the deed of your home and any other real estate you might own into the name of the trust. And there's three ways to do it. You can do it yourself by going down to the county courthouse where your property is located. They charge like a $56 fee. You fill out some paperwork and give them what's called a quitclaim deed. It's got the name of the trust in it, and you're done. And then if you want to make sure that it's done perfectly and you don't really have the time to go do that, there's a company that charges $75. It takes about 2 weeks, but that gets the job done, and that way you don't have to take the day off of work. And then the third option is having a law firm do it. But many times they'll send a paralegal down there to do it, or they'll use this company that we use for $75. They'll charge you $600. It'll cost them $75, and they get the profit even more. So that's the only thing that's going to cost you money in retitling. Then, once that has been funded, then everything is in the name of the trust. There's no restrictions on the property. You are typically the trustee of your trust while you're alive. The only thing that doesn't get retitled is typically the retirement fund. And we don't retitle that into the name of the trust because that would incur an immediate income tax event, which typically isn't so good. So what you want to do is you want to make sure that the trust is the beneficiary and not the owner of your retirement account. And that's very easy to do with a beneficiary designation form. And that's very common too. So we make sure in all these plans that we look at that that piece of the funding does not happen. So now you have this trust, and then at death, your assets can go directly to your family, charity, or others without any probate. It's very fast. So it takes about 3 days to get a death certificate from the funeral home, and then to go to the brokerage organizations and tell them a death has occurred. They want to see the death certificate, and then they'll get a form signed. So that takes about a week. That's not too long compared to the 18 months to 2 years in probate in most cases. And nobody knows who's getting your property or when they're getting it or how much they get. So it has a tremendous amount of advantages. And both of these programs have gone the extra step to say, how can we help people through this process? If mom and dad are gone and now the kids are sitting here and they're trying to figure out where mom and dad had everything, it's pretty confusing. You know, where was their checking and savings accounts? Did they have separate accounts at separate banks? You know, where are those statements? How was the house titled? Whose name was it in? Who drove what car? How was that titled? How about the investment accounts? Where are these individual stocks that dad said he had, and we can't find those in the drawers? All of those things. So imagine going through that process. It can take a year in some cases because the statements are annual statements. And so you kind of have to figure out, I know this is around, but we haven't accumulated all the information we need to know in order to go through this probate process. We allow you to spend maybe 20 minutes. Both of these plans have an area where you can list this, take the time while you're still alive, and that takes all the stress out of the post-death experience for your family. It is really a nice feature, and it just makes things a lot nicer for the family. There's 3 plans. I typically don't go through the simple plan because, while it's good and it does help you identify the beneficiaries, so it doesn't go through a formula. If you want everything to go to the surviving spouse, that's fine. So I say for estates that are under $40,000, that's probably still okay because most jurisdictions have an expedited probate. It isn't that much for estates that have $40,000 or less. So typically they don't own the home anymore, things of that nature. 99% of our clients look at a trust plan. And I think there's two really good plans that we have found that really give you a tremendous value. There's the Blue plan, and then there's a Lifetime Trust plan. Under the Blue plan and the Lifetime Trust plan, they give you the 6 major documents, and they both, of course, avoid probate. But the Blue plan has a nice feature in that they give you a completed quitclaim deed just to make the transferring of your home into the revocable trust a little bit easier. And I think that's a nice little plan and a nice little feature. And I was surprised that they did that. And so that's a really good plan. And then under the Lifetime Trust plan, it gives you all those same documents except for the quitclaim deed. They give you a sample quitclaim deed. And then they give you lifetime free changes, restatements, and amendments to your trust. So think about that for a minute. When my father was 91, he made 4 changes to his trust in the last year relative to his second wife. Imagine what the law firm charges for those changes. Under the Green plan, you don't have a charge. That's amazing. Just that alone, there is not a law firm in the country that has that feature, provides that option, and they cannot compete. I think that is just a tremendous value for your family. The Lifetime, that's just crazy. So they also have an online document vault, which gives you your opportunity to list all the inventory that you have of your personal assets online and list everything. So it's not just on a piece of paper now, it's on a form online, and each one of those assets is in a grouping where they help you fund those assets by giving you the instructions on how to fund your trust. So it is really helpful, and that's available 24/7. So imagine 10 years down the road, you have a conversation with one of your kids and they said, things aren't going so well in our marriage and I think we're going to get a divorce. And you wake up at 2 o'clock in the morning, God, did we make any provisions for that soon to be ex-spouse in our trust? And you can get online and read that section of the trust, and if it's okay, great, you go back to sleep. If it's not, you call the company up and they'll start making that change for you, and they won't charge you for that. They also give you a lifetime of free consultations. Imagine what it's like to have a need to have some questions answered, and you go to the law firm because they are your trusted advisor now. And how frustrating is it to get a charge for $300 or $400 for answering a question? My father-in-law, when he was getting his documents done, he said, hey, let's keep this next meeting under an hour because I just got the last bill and they're killing me. It's very expensive, especially at the hourly rate that they charge. And that plan includes all the assignments and everything you would need in order to have a complete plan. I think this lifetime free changes is just on the consultation piece, pays for the entire document package by itself, let alone having access to all the changes. Those are the plans. If you are interested in knowing or wanting to know what these plans cost, I would appreciate you texting me or setting up a time. We can go through any particulars you have with the family. We'd be more than happy to share that cost with you. But I think it's really important, just before we put the price out there, we know just a little bit about your situation. Can't change the prices on these, but they are well below what a law firm would charge in your area. And I would encourage anyone to go out and just do a little research, and you will find when you get back with us that these are the best overall value for you and your family. So how long does this take? Well, An interview takes anywhere from 45 minutes to an hour and a half, depending how complicated your situation is. That's just on an average. I've had 2.5 hour conversations with families because it's very dysfunctional and complicated. And once that interview has taken place, then we can get the drafts sent over for your review, usually within a couple hours. That's way different than what a law firm will do because it can take months. And then once everything is to your satisfaction, we'll send you the formal documents in a package ready for your signatures with little sticky notes where you need to sign, where the witnesses sign, and where the notary signs. And then once you've done that, we ask you to scan your documents and upload those to both companies so there's an online version of what you've signed. So if there's ever a fire or flood, then you have the opportunity to have another copy available. And believe it or not, psychologically, most people stop right there. They say, great, we've got our plan. But 70% of the trusts that are written by law firms are not funded because they really don't take much time making sure you fund your trust because they get paid 10 times more taking the family through the probate process. We take a lot of time and effort to make sure you fund your trust, and that can take a couple weeks. But once that is done, then you can check off your box that said you have completed your estate plan, for today, and that now you can go ahead and work on some of the other things you need to do. Everyone has an estate plan. Do you want to have your plan or do you want to have the state's plan? And I think most people agree, I'd rather have my plan. That's crazy. Please get back to us. If this is of interest to you, we'd love to talk to you. There's no obligation. And you let us know how you'd like to move forward.